Welcome for those who are joining us. Welcome back to those who have been here for a while. If you missed any of the previous sessions, they are recorded and will be available next week on our website, ableunited.com, specifically our YouTube channel. So youtube.com/ableunited. I'm happy to introduce to you Michelle Kenney, who is a founding member of GAPS Legal PLLC. GAPS Legal PLLC was created to serve the specific legal needs of the guardianship, advocacy, probate, planning, and special needs communities. So quite a robust set of services, Michelle, and just wanted to thank you for taking this time on Saturday to talk guardianship.
No, certainly my pleasure. So I'm going to try to share my screen. We'll see if that'll work.
Okay. And while we're doing that, we do have a quick poll that we're going to ask our attendees to kind of give an idea of who is serving in a guardianship capacity. Pretty good mix here. So, half or so are legal guardians and the other half are not. So pretty good reference there on who's attending. So go ahead and turn this over to you, Michelle, on guardianship. Thank you.
All right. Thank you again for having me. And I don't know that the slides are completely cooperating, but they'll do their best. And certainly I just want to make sure we have a conversation really about the legal options at 18. I want to take guardianship out of, the first line of defense and make sure that we appreciate that there's more than one option. So those of you that are already guardians, maybe you've been down various paths. Those of you that haven't yet, hopefully maybe I can better help you understand that it's not one size fits all. So to just kind of move forward and get started with where a lot of this comes from is at the age of 18, as parents, we stop having legal authority to make decisions on behalf of our child, even if it's very clear and obvious that they still need ongoing assistance. So, we're all presumed to have capacity at the age of 18. So it's normally someone, whether that's a doctor, the school system, Social Security, somebody comes along and says, your authority as the parent isn't good enough. And the reality is we've got, several different options. And those options range from staying out of the court system, looking at basic estate planning documents, and then guardianship being the most restrictive court intervention that we have, and recognizing that there are some families that choose to do nothing. Now, that's not the course of action that I would always recommend, but obviously there are some that it's overwhelming, it's scary, and so sometimes it just gets put off, and I know that's reality as well. And some of these options are expensive, so that's another variable too. I want to talk first about the least restrictive option that we have, and that's supported decision making. It's a fancy term. You may have heard about it, but it's something that we all do when we're faced with a decision when we need additional input or additional supports. So reaching out to those friends or family or trusted advisors to help us make decisions is plain and simply supported decision making. The difference is if we want to give it some teeth, to give it some strength when we're dealing with third parties or outside individuals, then we can actually have a written supported decision making agreement where that young adult is selecting their supporters, they're defining the scope of what that relationship looks like, and those supporters are then only stepping in those circumstances and at those times where they need assistance to make decisions. So it's actually a written document. It's something that we would work to put together. Exactly what that looks like for each individual is going to be very different. But working through empowering that individual to still continue to make decisions for themselves with, again, the same sort of supports that we would all need from time to time. And this all falls under the category of basic estate planning documents. Now, the catch with estate planning documents is that the individual, so this young adult, has to have the basic ability to understand the nature of what they're signing. I'm not expecting them to understand every legal nuance, because I know, plenty of adults, it can still be an overwhelming process looking at durable powers of attorney or healthcare documents, but ultimately some basic understanding of giving your rights away to someone else to assist you, or empowering, again, someone to make decisions on your behalf. But this is a document, many of us, again, we've heard about them. We may or may not have them for ourselves, but things like having a durable power of attorney to assist with financial matters, things like even opening your mail, signing contracts, those are the concerns that that document would address. The healthcare documents, generally our designation of a healthcare surrogate is to name someone that's going to assist with medical appointments, medical information, those sorts of social services. So that document, for healthcare, where the power of attorney is for financial. Those documents, either with or without a supported decision-making agreement, keeps a young adult out of the court system. But again, we have to have the basic understanding and the ability to sign those documents. And I don't mean signing your name, I mean the basic legal understanding of the relationship, this contractual relationship that they're entering into. And that's normally a determination that as an attorney I would make, meeting with that young adult. And I've had plenty young adults in a position with a developmental disability that could still sign estate planning documents. Other alternatives that stay outside of the court system are things like going to Social Security and becoming the payee for benefits. You don't need a court order to do that. Or certainly acting as a joint owner on a bank account. So there are some other alternatives to assist with financial decision-making, managing government benefits that don't need a court intervention. But now's where things start to get a little bit more invasive, more expensive, and certainly now we're getting the court involved when we're talking about a guardianship. Guardianship is governed by Florida law. There's an entire chapter devoted to it. It's currently 744, but for those of you that are guardians, I need to forewarn you, we're rewriting the chapter. It's going to have a whole new chapter number. So there are some changes that happen legislatively from time to time. But the whole intent of the guardianship chapter is that guardianship should really be a last resort. We should allow that individual to make whatever decisions they can, that they can still be actively involved in their own life, those kind of common sense themes that we would want for one another. It is, however, a legally defined relationship. So I always have to remind parents that you're not automatically the guardian then of someone that's 18. Just because you were the parent the day before does not mean then you really continue as a guardian unless the court has made that determination. So it is a legal appointment by a judge in your local circuit, in your local county, and it's something that is defined again under Florida law. And a guardian is really just a surrogate decision maker, somebody making decisions on behalf of someone else that has been determined to be incapacitated. And that individual basically can't manage their property. They can't meet their basic safety requirements. So again, managing those government benefits, managing bank accounts, certainly managing ABLE accounts. Those are the sorts of things that, would cover property matters when it comes to a guardianship, your medical decision-making, even the educational decision-making, residential and social fall more under those safety, the health component, those personal rights the guardian might be appointed. We're going to spend a few minutes on the rights because they're so critical and integral to this process. Here's a quick overview, though, of what happens when we start a guardianship file. We open a case with the court. There are actually two petitions that are submitted. The first petition is to determine that the person is legally incapacitated. That's what we're asking for. Part two is then a petition to have a guardian appointed. So whomever's applying to be the guardian, part one is this individual incapacitated? And then part two, if they need a guardian, who's going to serve, who's going to qualify in that role? And the court's going to send out an examining committee, we'll talk about them in just a second, to do evaluations of this individual. They file reports with the court. Then ultimately, we're going to culminate in a hearing, and that hearing is going to determine what rights are removed from the individual. And then ultimately, the court will issue orders. So that's the paperwork that comes out after this process. And then this is the part that most people don't like. The court's going to continue to supervise this relationship as long as there is a person under guardianship, as long as there is still someone with their rights removed. The court is ultimately supervising what the guardian is or isn't doing on that person's behalf. So again, as long as there's a guardianship, there is that court supervision and oversight. It's not, we do it on the front end and then the court goes away. That's not the case. So the court will continue in this relationship. Because we are talking about taking away someone's basic legal rights, the court will appoint an attorney to represent the individual through this process. So that young adult that is alleged to be incapacitated will have an attorney appointed for them by the court, and that individual is either paid from the assets of that individual if they have assets, and that's a court determination. If they do not, then the state of Florida pays for this attorney to represent them. So they have a right to an attorney, the state provides the attorney, and they are representing this person's interests in this process. Again, we're taking their rights away. We want someone to be able to represent what they want. So that attorney gets appointed. I mentioned that we have an examining committee that goes out and does an evaluation. And that examining committee is made up of 3 different individuals, normally different types of disciplines. So we might have a regular primary care physician. We could have a psychiatrist, a neurologist, a psychologist, sometimes a sociologist. There might be a nurse or a social worker. So we kind of have these a different mix of different disciplines that are all evaluating this individual from slightly different perspectives. And they're going to file a written report with the court. And that is some of the primary evidence that the court is going to then take as to whether or not this person is incapacitated. So it's not the only evidence, but it's certainly a big piece of it. Some of the protections that are in place at this hearing is that we have to reach the clear and convincing standard of evidence. So that's a pretty high bar. It's not just because we think this person is incapacitated. We have that court-appointed attorney who will also be making the determination on whether or not the person has to attend the hearing. They have a right to attend the hearing. They certainly can confront any witnesses, put on their own evidence as to why they're not incapacitated. But if the process might be too overwhelming, or there's not a benefit that the court might gain from meeting the individual can say they don't want to attend. The attorney can waive their presence. So in some cases, it's hard for our young adults to differentiate between a criminal proceeding and a civil proceeding. So sometimes even just coming into the courthouse and the formality of what that means can be terrifying and overwhelming. So again, that court-appointed attorney is the one that's going to work with them to determine if they want to attend the hearing or if they otherwise want to waive their presence. We have to look at alternatives to guardianship. So those estate planning documents I mentioned before would be one way to avoid a guardianship altogether. We'll talk about a least restrictive alternative to guardianship in just a second. But otherwise, the court has to, look at, is this truly the only option we have? Have we made sure that there are no other alternatives available if we're going to go the most invasive route? So what rights are we talking about? Well, first, I want to be very clear there are certain rights that we do not take away. We do not take away what I like to consider dignity rights, things like, the right to be independent, the right to be restored to capacity, to have a qualified guardian, that right to an attorney, that right to even attend the hearing, the right to express your preferences and have visitors. There's a laundry list in the statute of about 15 rights that everyone's going to always retain. The rights that we're talking about potentially removing, however, those are kind of broken up into two different sets. And I say that because there are what we call personal rights that might be taken away, but they are never delegated or given to a guardian. And then we have those rights that might be removed and could be delegated or given to the guardian. So I'll start with the first set, those personal rights, things like the right to marry, to vote, to personally apply for government benefits, to drive, to travel, and to work. Those are primarily in the statute. That's how it's written right now. There is going to be most likely an addition of the right to own or possess a firearm. Right now, the court will remove that right, but it's not one of the enumerated ones under 744. So just because of a mental disability, because of Stoneman Douglas, that's one of the rights that the court will also evaluate in addition to the ones in the statute. And just to clarify, that doesn't mean that a person under guardianship can never travel again. These are just the personal rights to make these decisions for yourself. So for instance, I can't go get a driver's license for someone else. You have to go to the DMV and do that yourself. You have to vote, obviously, for yourself. I'd still like to figure out how I go to work and someone, or rather someone else goes to work for me and I collect the income. So this gets back to those things that we have to personally do for ourselves versus those things that someone else could do for us. And that's the other set. So things like signing contracts, suing or defending lawsuits, managing government benefits. And the difference there is only the word personally. Managing property, so whether we're giving property away, we're disposing of it, we're receiving new property. So any property, and we're not talking real estate, that could be bank accounts, that could be sources of income, any other assets or income that this individual might have. Consenting to medical or mental health treatment, determining residence, and making those social decisions, you know, what we like to do in our spare time for our hobbies, and all of those things collectively basically boil down to what we can do for ourselves. And in the court process, those are the rights that are at jeopardy of going to a guardian. So just those last 7 that I covered would go to a guardian, even if all of the rights were ultimately removed in the incapacity process. So that's something to keep in mind, that this is a very invasive process. It's something that we don't take away someone's rights very lightly. And, you know, those 7 statements basically give me the ability to control all those different facets of someone's life. So we want to make sure that that gets back to having a qualified guardian. So the court is going to do a background screening. So there's an application that the guardian will fill out. You're going to have to go through a credit and a criminal check. So it have to be fingerprinted. There is also then an educational requirement that you have to meet. There's an 8-hour class in the state of Florida. So that's something that you just need to recognize. The court wants to make sure that the person that we're appointing in this role, that's going to have the authority over all of those significant rights, is someone that's qualified. And unfortunately, sometimes parents don't qualify. There might have been something in their past that they, you know, had forgotten about, something you did that was stupid in your 20s. And now, because of the requirements in the guardianship chapter, you don't qualify. So that is a concern sometimes when we are looking at who that guardian might be down the line. So someone else in the family that might come in as a successor guardian, making sure they qualify. So that is an important consideration. Not just anybody that's family is going to be appointed. So remember, there's some hoops that you have to jump through in the beginning just to be appointed. Again, just kind of raising your hand and saying, but I'm the parent, is not sufficient enough. You're then going to have initial reports that have to be submitted to the court, as well as ongoing annual reports that are submitted. So this is some of that court monitoring that I mentioned. So the court making sure that you're doing what you're supposed to be doing, that you're providing for the basic care and support of this individual. So both initially what you're proposing, and then on an annual basis, continuing to kind of check in and make sure that those services are in place, that there's an annual evaluation by a physician, basic ongoing monitoring. So now that that might have overwhelmed you, we'll talk about a least restrictive alternative, but it is still a court process. And that's guardian advocacy. And you'll see there, Chapter 393. It's governed by a slightly different chapter in Florida law. But once a guardian advocate is appointed, it says, look at all the rules in the guardianship chapter. So how a guardian advocate is appointed, the process is a little bit different, but the end result, this authority as a guardian, is the same. And that's why 744 is still going to come back in for some of those basic requirements. So guardian advocacy can only be used for an individual with a recognized developmental disability. So it had to have manifested before 18, is expected to continue indefinitely, and has to be one of either an intellectual disability, cerebral palsy, autism, spina bifida, Down syndrome, Phelan-McDermott, and Prader-Willi. So those are at least the ones that are identified in statute right now. Otherwise, we're talking about a guardianship. Guardian advocacy can only be used with someone with a developmental disability, again, recognized in the statute. So now that you know about guardianship, it makes it easier to talk about guardian advocacy. And that's because it's almost like a guardianship light. There is no petition to determine that the person is legally incapacitated. So we skip the examining committee, we skip that whole process, because we're basically going to accept that developmental disability as our evidence. And there are pros and cons to that. I have to tell you, I have a sibling with Down syndrome. I don't like that we kind of put everybody in the same basket. And that's why your legal options are not one size fits all. It depends on that young adult. It depends on their strengths. It depends on what those weaknesses might be. And so are we going to use a legal finding of incapacity, or are we going to just use their developmental disability? That's kind of one of the pivotal points that we're looking at in the difference between these two. So we don't have the examining committee. If the only rights that you are concerned about are the right to make those medical or mental health decisions, the right to make social decisions or residential decisions, then under Florida law, you as the petitioner, the person asking for this guardian advocacy, you do not have to be represented by an attorney. In a guardianship and a guardian advocacy that might have those additional rights like contracting and managing other property, you do have to be represented by an attorney, and that is for the duration of the guardianship. So that court-appointed attorney for that young adult is going to go away at some point. But if you are the guardian or a guardian advocate with property rights, the attorney is going to stay in the picture. I didn't make the system. It's just what it is. So guardian advocacy, again, if it's just a couple of those rights, and that includes generally the right to make, the right to manage public benefits, you would not need an attorney to assist you through this process, although that doesn't mean you certainly can't work with someone, because I know there are a lot of questions that can come up. It also means that when the law changes, you don't always have that support to go to. Sometimes the clerk's office is not always the most forthcoming with information. But you're still going to have at least one petition, so you don't have two, but you have one asking to be appointed as the guardian. You still have a removal of rights, but the difference, the primary difference between these two is that that young adult is going to keep all of those personal rights. So the right to marry, to vote, to travel, to work, those rights remain intact. We don't even look at them in a guardian advocacy. So we are only focusing on those rights that are delegated to a guardian or a guardian advocate in this process. You still have initial and annual reports, so I can't get you out of that. You still have the background investigation. You still have the educational requirement. You still have the court supervision. So a lot of those basic administrative pieces will still be the same, whether it's a guardianship or a guardian advocacy. It is just really that legal determination of whether or not the person is incapacitated, that examining committee process, if you will, that is kind of that deciding factor, and the rights that are actually removed. Everything else, for the most part, is going to be identical. So this is just another reminder. Guardianships are for anyone, doesn't matter the disability. An attorney is required for the process, and that's representing you as the petitioner, the one asking, as well as then once you're appointed as the guardian. There's the examining committee, there's the order determining the incapacity, and that means there's 2 filing fees. Just plain and simple. We'll talk about costs in just a second. With the guardian advocacy, it has to be for someone with a developmental disability. There's no attorney if it's just those personal rights. Again, that's the attorney representing you. There's no examining committee, which also means there's no order determining incapacity. And I can tell you practically that sometimes that's a problem. Sometimes you have a doctor that says, show me this person can't make decisions for themselves. Now, your order as a guardian advocate should be sufficient enough, but ultimately there is no legal determination from the court that your young adult is incapacitated. But again, only 1 filing fee, so it is certainly less expensive. So again, which way you go ultimately is going to be determined by the type of protection that you might need for your young adult. Sometimes they cannot exercise any rights on their behalf. And the statute says for a guardian advocacy, they have to be able to do some tasks on their own. So could they make some decisions independently? Do they need complete assistance? That also might be the decision between one or the other. So to recap the different legal options that we've talked about, estate planning stays out of the courthouse. Guardianship and guardian advocacy, you've got the court involved as long as there is a case. We've got the court supervision. So here's where some of the costs come in. Basic filing fees, sometimes those filing fees can be waived or reimbursed, but you are still talking several $100s. You've got the background screening, you've got to take the class. So just some of the hard costs, even if you have an attorney that's working pro bono or it's a legal aid or someone that's providing that legal assistance at no cost, there's still some hard costs that you might have to incur. So that's something to just keep in mind. If it is a matter of setting aside a little bit of money here, here or there, so that you have something to work with when your child turns 18, that's something just for planning purposes to recognize we can't avoid costs altogether. So a couple years ago, since I work with a population where this question comes up all the time, I was fortunate enough to work with the Florida Justice Technology Center to create a website. So that's turning18.org. The word turning, TURNING, and the number 18.org to help you navigate all these different decisions. It is not intended to provide you with legal advice. It is intended to just be educational, informational. When you have those 2 minutes in the middle of the night, and that's the only time to yourself to go and try to find some of this information, and you can then better see through a series of kind of guided information where your child might fit, whether that's signing estate planning documents or guardianship, guardian advocacy. And then at the end, basically, because you can't avoid some of the shortcuts to get through the information, at the end, there are some legal resources, as well as if it's in a guardian advocacy that's appropriate, and just those personal rights. So again, without an attorney, the website will help you fill out some of the forms. So depending on your county, depending on your circuit, there are some variations there, but ultimately I wanted there to be a tool where you could get some of that basic information and not have all these questions about, where you really see your child fitting in, so that when you go to have that conversation with an attorney and make sure you're on the right path, you're better informed. So just some basic page navigation to kind of help you walk through, again, giving you the different legal options or the forms to fill out. So all of that information kind of in one place. And I would certainly be remiss if I didn't then mention your own affairs, making sure your own estate plan is in place. Plenty of adults end up with life happening, and then you might need a guardianship for yourself, or certainly just even that succession planning. If something were to happen to you, and this guardianship might be for your lifetime, do you have the appropriate documents in place to name someone to take over and what that might look like? So basic special needs planning, those sorts of considerations are certainly just a part of the practice. And then basic disclaimer, obviously one size does not fit all, and none of this should be taken as legal advice, but wanted to make sure that I had the time today and the opportunity, certainly very grateful for it, to go ahead and get this information out there. And John, I know we wanted to leave some time for questions, so certainly I'll turn things back over to you for that.
Awesome. Thank you so much. Michelle, this is a great presentation. I know I learned a ton. Hopefully those that are attending learned quite a bit. And we do have a handful of questions as it relates to guardian. One is the whole idea of, can you have more than one guardian? So think of a mother and a father, or maybe a sibling. How does that work? And can you appoint joint guardians?
Great question. I love that question, because sometimes I think there's a thought that only one guardian can serve, and that is certainly not the case. So we can have co-guardians, that's the technical term, where we have two guardians serving together, and that normally is the parent, but sometimes it might be a parent and maybe a younger but still adult sibling. So a guardian still has to be at least 18 years old. They still have to qualify, but then you also share some of that responsibility. So it makes it a little bit easier if one parent can't act, especially if it's a medical crisis. We still have that second guardian that could be available. So you have a built-in backup if something were to ever happen. So you could start out being, a sole guardian and have a co-guardian come in later. You could also be a co-guardian and switch out. Maybe again, if something happens, bring in a different co-guardian later on. So that type of dynamic can certainly change. But again, as long as the guardians qualify, I have one case right now where there are 3 guardians. I don't always recommend that because everybody has to sign off on everything that goes to the court. But, obviously that sort of flexibility still exists in the law. So great question.
That's great. And now I think you tackled this, but just to reemphasize, so incapacitation, right? The court ultimately decides that. Can you describe what is incapacitated? What was the court considered an individual to be incapacitated?
Well, I know it's kind of vague the way the statute defines it, right? Just not being able to manage your property or to provide for your basic health or safety. But I think, because guardianship was intended to cover the entire range of, our elderly with a dementia or some other sort of cognitive impairment, as well as those individuals with a mental health diagnosis, brain injuries. So you're talking about all this range of different types of inabilities. And the incapacity piece is really when it comes to your cognitive functioning, right? So this is the big distinction that I like to make to parents. Your children are allowed to make bad decisions. Guardianship is not going to prevent bad decisions. There would be plenty of us under guardianship if that was the criteria. So some parents go into this, and I don't like the term, but I'll use it just because I think it's descriptive, that helicopter parent, that they want to be super protective of their child so that they don't ever do anything that they shouldn't and get in harm's way by signing something they shouldn't have. But honestly, that's also how we learn. We learn from our mistakes. So the court's looking at that incapacity as a legal finding that you truly cannot weigh information. So you can't take the information in to look at the pros and cons, to be able to then process the information, to come to some sort of conclusion. So even if it's the wrong decision, you can't process that information to get the output that you might need. So really being able to take the information in, weigh the costs, the benefits, the pros, the cons, get all that different input, and then say, okay, this is what I decide. So not having that basic foundation is kind of what the examining committee members are looking for. And again, we all have good days and bad days. We all make good decisions and bad decisions, but it's the ability to process information. So you can have someone that's nonverbal, but obviously can still communicate their decisions. So it's not just, again, someone's just, requires complete assistance and is nonverbal, therefore they're under a guardianship. No, we have to go that step further and really see what does the processing of the information look like. So, but that's really a gray area. So that's why it's a court process. So that's the best I can do to give you kind of some insight there.
I appreciate that. Something I want to talk about, and this is a question I actually got on Friday, was about the whole idea of the accounting, right? The yearly report that has to go in, and where does ABLE accounts kind of fall into that requirement for reporting? Is that a yes, no, depends on the judge, or how does that work?
I'm going to give you the attorney answer. It depends. Yes, because it is all the above, right? So I would say the majority of cases, ABLE accounts are included in the accounting, right? But in some cases, I know they've been excluded. So I, for instance, have a case where the young adult wanted to use an ABLE account for saving some of their part-time employment income. And we don't want to penalize them, right, by taking that money out of their hands and out of their control. And we want them to be learning, money management skills. So I actually went the step of getting a court order to exclude the ABLE account and to exclude the accounting of those funds from the guardianship. So it might have to be a proactive step depending on the judge's stance. If the judge says, I want it accounted for, then you have to account. And yes, it's an asset that might be available to that individual. So I understand the court supervising that piece. But that doesn't mean as attorneys, we don't sometimes have recourse to say, but Your Honor, let's not penalize this individual for trying to save. So as long as we have a court order that says it's out, it can stay out. But again,
Awesome.
that's normally a proactive step. It's not an either or unless the court has made some sort of, statement about it. And I haven't seen many circuits that have come out with a position specifically on ABLE accounts.
I appreciate it, Michelle. And I know that's something we're constantly working at, is how do we get to those various courts and systems and educate them on ABLE and see how we can best be of assistance to them from the state. Here's a question, and this kind of ties into a little bit earlier on Travis Fincham's Special Needs Trust. If you missed out on that, that will be recorded, but this kind of deals with both custody. It says divorced parents who share a liberal custody agreement, do both parents need to have a special needs trust set up for their daughter?
We got a bunch of different issues going on in that question. But no, normally one special needs trust is sufficient, especially if it's a standalone or, if it's a pooled trust. Who's contributing to that trust and who the beneficiary of that trust is doesn't obviously take the parents each having their own trust. So, recognizing that young adult is the beneficiary, normally if it's a third party trust, whoever's putting the money in, we don't really care the source. So most families, even in divorce cases, I've seen one special needs trust. Now that's different. So let me mess with things, John. That's different than each parent having in their will or in their trust as a part of their estate plan, a testamentary special needs trust. So remember, and I don't know if Travis got into this, we can have more than one type of special needs trust for one beneficiary. So there could be a special needs trust that each parent creates as a part of their estate plan in addition to the standalone. So I'm going to go back with it depends to be safe.
Yeah, that's a good question. I know that was a multifaceted type of question there, and I appreciate your answer. Question on guardianship law. What happens if there's no plan in place and the guardian passes away?
That's an unfortunate, and that's where we do have offices of the public guardian in the state of Florida. So that is where someone would truly be a ward of the state because there is no family that could serve in that role. But guardians can be, as long as they're related by blood or marriage, they can serve from out of state. So maybe we do have a distant family member that's willing to act in that capacity. It doesn't mean they have to live with and care for the ward. So just, making that distinction that young adult, they don't have to take custody. I know you use that term with the other question, but, guardians do not have to be a custodial parent in that sense. So I have guardians that are serving from out of state. So if it's a third cousin, I've also had friends that have just known this young adult for many, many years. Sometimes it's the parent of their own adult disabled child that have taken in, this young adult. So I always say it's better for the family to obviously be making that decision while we still have that choice. But the long and short of it is the court does have not only the office of public guardian, but professional guardians that might step into that role if we have to. And we'd much rather have somebody that knows that individual than a stranger making those decisions.
That's a good point. That's a good point. So we get this question, and this will be one of our last questions. But if individuals do have questions, they can go ahead and use that QA box on the bottom of the Zoom to input their question, and we'll try to get to it. This is a good question, and we receive this occasionally as well. Is, hey, I'm in XYZ city here in Florida. How do I find an attorney local to me? What's the best place for me to go and find a local attorney?
Well, so this is where guardianship falls under kind of a niche specialty, that it's not the first place for you to go look because it's elder law, right? And I don't necessarily promote myself as an elder law attorney because I work with a lot of younger individuals. And for that matter, my 85-year-olds don't like being called elderly. So, it's something that an elder law attorney is obviously a place to start. There's, here in Florida, there's the Academy of Elder Law Attorneys. Certainly you can look on the Florida Bar website for an attorney that might be board certified in elder law. There's a National Academy of Elder Law Attorneys. But you also have the Academy of Special Needs Planners. So obviously someone that might bring, not just the special needs planning, but the guardianship component as well. But you really have to ask, because what we're starting to see now, and it scares me a little bit, is attorneys that are dabbling. So, it's one of those things that, for instance, I'm not board certified, but I've been in the guardianship community for 20 some odd years. So, it really is sometimes word of mouth. But obviously the Academy of Elder Law Attorneys, the National Academy, even the Florida Bar website looking for a board certified elder law attorney are some places to start. And then every county normally has their local bar association that also has a attorney referral option. So, at least a couple of resources to start with.
Yeah, that's great. And to do your research, I think that's a good point to find out, don't be afraid to ask that attorney those questions on their experience working in guardianship and their history and some background, instead of just saying, well, I found your name in the yellow book, or I don't know if that's still a thing or not. But
somewhere, but
I saw it,
point, because I think I get calls all the time, someone asking me, I need to do a guardianship. And by the time I'm done speaking with them, a guardianship is not what they need. Maybe it's an advocacy, or maybe they can sign documents. So if you call an attorney asking for a guardianship, and that attorney doesn't really specialize in this area, or they're not sensitive to the needs of this area, they might sell you something that you don't need. And so asking, how many cases have you done for a young adult with a developmental disability that isn't a guardianship might be a better question to ask. So
that's great. This question just came in, I thought was good. So let's say, guardianship, either professional, guardianship or advocacy guardian might be in my future. I just don't feel comfortable serving, or nobody in my family does. How do you go about finding either a professional guardian or a public guardian?
Sure. So all of that information for public guardians and professional guardians, they have to be registered with the state of Florida. So it's the Office of Public and Professional Guardians. And they have a website where you can go by county and see who is literally currently registered. One of the things you're going to probably need to do, though, is talk to an attorney, because obviously just looking at a list of names of, those guardians aren't going to help you kind of qualify. So just like you'd interview an attorney, you'd want to interview the guardians. And professional guardians all have different specialties, different practice areas. I actually started in guardianship as a professional guardian. So there is also the Florida State Guardianship Association, where guardians can join. So that would obviously give a little bit of, if they belong to a professional association, little pieces like that. So different resources that are out there for finding professional or public guardians also.
Wonderful, wonderful. Well, Michelle, thank you so much for taking some of your Saturday morning, afternoon with us to talk about ABLE accounts, talk about guardianship and what resources are available to families. I know it was very informative to me. I'm keeping those slides. Just as a reminder for those individuals that have joined us, you missed any of the previous presentations, they have been recorded, but we also have a takeaway document that we'll be emailing out that's going to have these presentations along with some key takeaways from some of our other roundtable panelists. But Michelle, any final words before we wrap up?
It has just been my pleasure. So thank you so much, John. Certainly look forward to anything I can help answer if there are any questions after.